Okay, types of distributions. We're going to learn a bit of Greek in the two ways that an estate can be distributed. So the first one is per Stirpes or Stirpes, depending on the pronunciation, which means by branch. And the second one is per capita or per head. So let's go ahead and look at two examples that will bring this to light. So let's imagine that I have three children, Alice, Bob, and Charlie. And then in scenario one, I pass away. And if we go in the will, it mentions that the distribution is per Stirpes. Everyone gets a third. Alice, Bob, and Charlie all get 1/3 of my estate. However, let's suppose that one of the child predeceased me. So in this example, it's Bob. So Alice, Charlie are alive. Bob predeceased me, so he dies before me. Bob has two kids, David and Emma. And so the share is now divided in three, so that Alice gets is the third, right? And then 1/3 is also Charlie, but the kids, David and Emma, get that 1/3 divided in two, so that they get 1/6 of the estate. So this type of distribution does not impact Alice and Charlie, but for Bob, his kids get then their share split in half. Okay, so that's per branch. Now, if you go per capita, that's per head. So in the example where it's Alice, Bob, and Charlie, and then if I die before them, then everybody gets 1/3. But if Bob were again to predecease me, then David and Emma would get. Then everything is divided in among the remaining descendants. So it's now Alice, Charlie, David, and Emma, and they all get 1/4 of the estate. Okay, so it's important to understand the difference because it might impact your distribution, and especially if in the context of grandparents, they're thinking of their kids, they have grandkids, and how is the estate supposed to flow from kids to grandkids? If it's per branch or per head, could have an impact in ultimately how much every descendant has in terms of the remaining estate. There's someone in the waiting room. We're going to admit that person. All right. And continue on the presentation. Okay. So we've talked about the will, last will and testament, legal document of great importance. It's the one that most people understand and know. But there's another type of document that's equally as important, and it's the power of attorney. So in a nutshell, it's another legal document where you give the authority to act on your behalf to someone else. And the two types of activities that other person can take, so the attorney, is either to manage your property or to manage your personal care. So you can see it, just to give it an example, say that I fall into a coma and I'm unable to make decisions regarding my finances. If I have signed a power of attorney, then that person has the ability to manage my affairs. If a house needs to be sold and I have a power of attorney for property, that person can sign on my behalf for the sale of that purchase. And that's really a key element of importance when you deal with mental health. People with Parkinson or people that have mental issues, mental illnesses, you want to be cognizant that if they don't have a power of attorney for property, and once they fall into dementia or what have you, at that time, the lawyer won't be able to assess their capacity to appoint you as their attorney, right? So that's also another element about why considering today, not tomorrow, because we don't know what tomorrow brings. And too often, we get contacted by people who are trying to help. And they say, my friend here is in the hospital. He's not all there, but here he is. And he needs to talk to you so I can be appointed as the attorney. And that's a situation that raises a lot of red flags, because how am I supposed to assess the capacity of that person? And that can create some trouble. The other side, the other type of power of attorney that can be used is the power of attorney for care. And again, let's take the example that I fall into a coma and some medical procedures have to be performed on me. If I don't have the power of attorney, the presence of a power of attorney could mean the choice between the health care that I get. And the example I often use is for people that have religious beliefs where it impacts the type of care they can receive. If the attorney is aware that this person belongs to a certain denomination, then they're going to make decisions in the best interest of that person as if they were alive, right? And that can be tricky sometimes, because if you know, there's cases that went all the way to the Supreme Court where a doctor was trying to save a patient, did a blood transfusion where the patient itself was of the belief that they could not receive blood transfusion. Doctor was trying to save a life, but then there was also religious beliefs that were in conflict, and that doctor was also received a slap on the wrist, right? And so two very important documents for the property and for care. And something to know also, the attorney for care or property cannot change a last will, a testament. Only the testator can change their will, even if they have named an attorney for care, an attorney for property. Let me just go back in the presentation. Thank you for your indulgence. All right, so giving a lot of information about the why, I'm hoping that you're following along, you're understanding the basic concept of what's a last will and testament, power of attorney for care, and power of attorney for property. And so that's some of the documents that form part of your estate planning success and progress. But too far often, for whatever reasons, there's people tend to have misconceptions as to why or whether or not estate planning applies to them. And for some people, it's cultural, right? For some people, it's, there's an anxiety that comes with sitting down and thinking about what's going to happen when I'm not there. In some cultures, talking about wills and estate is almost wishing death upon the person. But we're going to try and demystify some of the misconceptions that we see often regarding estate planning. So the first one, estate planning is only for the wealthy. And because maybe in the word estate, you're thinking about these vast domains in the UK with like a big castle, and that's an estate. And if I don't have an estate that big and that wide, then why should I bother about estate planning? And regardless of the size of your estate, making the decisions that are gonna give you control about what happens when you're no longer there is really what should be in the forefront of your mind. It's not so much a matter of the size of your estate, but the fact that you want to have control over what may happen to it when you're no longer there. We talked about healthcare, especially if you have children, and more so if you have many children and different assets in different locations. You're just planning so that it's easier on the people that are left alive when you're not there. So no, estate planning is not only for the wealthy, it's for anyone and everyone who cares about their loved ones, okay? Let's go to misconception number 2. A will is enough. Okay, so a will is a good start to an estate planning, but there could be it's one of the many aspects. But what you need to think about is have a comprehensive approach. That's why when you sit with a lawyer, most of them will ask you if you have an accountant, if you have a financial planner. They're going to ask you questions to ascertain what, if any, documents beyond your will do you need to keep in consideration. They're going to ask you about TFSAs, retirement assets, any and every aspect of what could form part of the estate to bring you to think about it in a very comprehensive manner. And for those of you that are joining from Gatineau on the Quebec side, the province of Quebec has been a bit more forthcoming when it comes to assisting people who want to die, right? There's laws that have been enacted so that there's a way that it's done. And it's not so clear in Ontario just yet. And so that's why, it's an important conversation to have as to whether or not maybe a health directive is a document that you would want to add to your the full estate planning. So you want to be sure that all these additional documents are respected and that you would consider all and every scenario that can present themselves. Not to say that we can predict the future, but an experienced lawyer will be able to extract from the conversation what are your needs and provide solutions to that.